it's the item number 19 and 32. So for adjournment, 2 weeks later.
1932.
19 and 32.
Yes.
After at least after 2 weeks later.
In whichever matter you need an adjournment, please tell the Mrs. Verma, and then you give the slip to the courtmaster. I may not spend my time then. And pay for listing, give it to the courtmaster. Give a slip and please inform her first.
May I be allowed?
Except for matters where you need these affidavits to be brought in.
Lordship, I beg to mention item number 8. I may be allowed to withdraw this petition.
8.
8.
Okay. 8. Upon instructions, Mr.
AMS Majumdar.
AMS Majumdar, counsel for the petitioner, seeks to withdraw this petition. Prayer is allowed. All the respondents are represented. Matters are dismissed on withdrawal. Interim order, if any, stands vacated.
Lordship, sub-release item number 44, the matter may be fixed at 2.
Okay. 44.
44, sub-release 44.
Okay, you inform the
Obligation.
what do you call the counsel for NCB. Inform the counsel for NCB.
May I please, Your Worship, I beg to mention item number 16 of the daily list and 42 of the supplementary list. Contacting counsel, Mr. A.W. Aman is unwell today, Lordship.
Yeah, we have told you. Give a slip to the courtmaster.
If you
Inform her and then inform the courtmaster.
Daily list, item 1 for motion.
We have filed affidavit, our affidavit.
Hmm?
We have filed our affidavit.
By when you are filing? By when you are filing? Okay, then we list it after a week. Okay, Friday being sandwiched with the holiday, make it Monday. Both sides are represented on the prayer made by Ms. A. Verma, Leonard, standing counsel for the Home Department. List after a week so as to enable her to file affidavit in opposition in course of this week. 19th. Make it 19th. Okay.
19/8 no.
Huh?
19.
Oh no, not on 19th. 19th, 21st. We have a fixed matter on that day.
Item 2.
May I please, Your Lordship? This is a contestant case. Lordship, petitioner did not receive any notice, and as such, the petitioner could not appear before the tribunal below and could not submit a written statement with relevant document.
Where is the
Accordingly, the case
how many
decided
dates did you
ex
take?
parte wide order
How many
dated.
dates did you take?
Lordship,
How many dates did you take? How much did you take?
ex parte, Lordship.
Please try to understand. You have heard the question. How many adjournments did you take?
Page 33, Lordship.
Huh?
Page 33.
33.
3.
Ms. Verma, we set it aside and send it back. Only one date. The page 34, process server was 37 and ex parte order was. Yes, that's why. On the first day, it was heard for ex parte. Okay. Hmm. Okay. Heard Miss
A. Hussain.
A. Hussain, counsel for the petitioner. Ms. Verma for the Home Department. Ms. P. Barwa for the you're for the Election Commission for respondent number 3. And you're also there for CGC for Union of India. Acha. Okay. Mr. Your name and everything. Number 4. Oh no, it is like this. FT, then first second bracket, K within bracket M, bracket closed, dash 4, second bracket closed, 83 of 2018. Wherein the member, Foreigners Tribunal, 4th Kamrup, had passed an ex parte opinion dated 38/2018 against the petitioner, holding him to be a foreigner who has entered into India from the specified territory after 25/3/1971. The opinion was an ex parte opinion. And from paragraph 2 of the impugned opinion, it appears that the process service report is dated 37/2018. And as the petitioner was absent, order dated 21/8/2018 was passed to proceed ex parte in the matter on 24/8/2018. And thereafter, the ex parte opinion dated 38/2018 was registered. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned counsel for the respondents. within 2 days. Next one, let the records be called for. Next one. In the meantime, that bill 5,000 with the satisfaction of the Superintendent of, Deputy Commissioner of Police within bracket B, Guwahati. Next matter. The Learned Standing Council for the Home Department has raised a question of has submitted that the writ petition is filed at a belated stage to challenge the opinion dated 30/8/2018. Full stop. Next matter. Objection, if any, by the respondents be filed prior to the next date of listing. List after 4 weeks.
Lordship, interim may be granted. Interim.
We're giving you to the, we're giving you.
It is Deputy Commissioner of Police, Kamrup M.
Yes, yes.
Item 3,
May please your lordship. My lord, here in this case, my lord, matter was contested and declared foreigners. Grandfather, father, my lord, they are voters in 1966. My lord, in 1966, my lord, kindly have a look at page 33, Annexure 2. Majamali is the grandfather. Then, my lord, father is also voter in 66, page 35. But in the same village, different house number. And that has been taken up by the tribunal that father and grandfathers are in voters in different house number. My lord.
Where is the opinion?
Yes, my lord, at page 78, lordship may kindly have a look at page 8, running page 8 of the impugned opinion. At page 85,
Yes.
under paragraph 13, my lord, exhibit C and C1, D1 are the certified copies of 66 and 70 respectively, where OB projected grandparents as Majamali and Bhatannasa.
But
Parents-
it's a very happy family. You don't know the name of the grandmother.
My lord, maybe, my lord. My lord, there is a, my lord, a customary, my lord, of the Muslim family of the remote village, not all. They do not want to say the mother's name, grandmother's name. They do not try also to keep it memorable. That may be also reason, man.
No, that can't be believable. He is being declared a foreigner and does not want to say the mother's name.
Grandmother's name,
That's okay.
my lord. My lord, he may forgot, my lord, in the dock, my lord, he may out of nervous, he may also may not say, may not recollect, my lord. And for that reason, our prime evidence that has been discarded by the learned tribunal. The poor illiterate people of the remote village.
Very difficult. You see, you under your religious customs, every year you go to the graveyard and make a prayer for the people who are dead. What prayer do you make if you don't know the names of people for whom you are praying?
My lord, I also do not know my grandmother's name. I forgot,
Very
my lord.
strange.
I never tried to recollect my grandmother's name. My lord, can it be a ground, my lord?
It means that you are picking up the names here and there from the voters list and then making them.
Absolutely wrong, my lord. My brother was examined, and my brother is also voter with my mother. I am also voter with my mother. But
Shows-
voter list are my lord, my lord,
shows that-
single voter list.
Shows that
My lord, kindly have a look at, my lord, the voter list of 97 at page 49. This certificate copy, when certificate copy was furnished, only my lord, single unit. Omar Ali, the petitioner, his wife is there. But here, my lord, kindly see the voter list of 97. I have given the complete voter, the part of the complete voter list at page 90. Here, my elder
Page?
brother, my
Page
page 90.
90.
Yes, my lord, 90, annexure 20. My elder brother, Somed Ali, he is examined. Then, my lord, Umar Ali, the petitioner, Sunaban Nasa, his mother. They are in the same but adjacent village, adjacent house number, not in the same house number. That when certificate copy is given, my lord, single unit has been given. Only these things are, tribunal has taken up a negative view, my lord, for not having proper explanation. That is also fault on the part of the proceeding. Kamrup, my lord. My lord. My lord. Interim, my lord, will be developed.
Item 4,
May I please, your lordship? My lord, in this matter, the petitioner has contested the matter and relied 3 evidence as well as exhibited 4 evidence, my lord. And but a learned tribunal has, my lord, the independent witness of PW3 as well as the exhibit 1, which shows that my father, prior to 1961, has revenue receipts are overlooked, as well as independent evidence of the PW3 also overlooked, my lord. Lordship will find the my lord will find it is at page 21, my lord. My lord, in paragraph 9 and paragraph 10, my lord, and also in my evidence on oath, my lord, I have examined PW3, my lord. Page 42, my lord. Annexure 8. And for Lordship will find his evidence in chief 41 and cross at page 42. Mohan Singh, my lord. And cross at page 42, my lord. Satisfaction of bail. Satisfaction of bail. Kasar. Yes,
Yes.
Kasar, my lord.
Bail to the satisfaction of?
SP Kachar.
SP
Yes.
Border Kachar. You give her copies within 2 days by
Yes,
tomorrow.
my lord.
Give her copies.
Obliged, my lord.
Item 5,
May I please, your lordship? This case is, writ petition is filed against the opinion dated 11/6/24 in BNG FT2 APR 566/2016. Page number 14 is the opinion.
Page?
14. 1/4. Opinion is given in page 20, last part.
Ms. Verma, we'll have to attend this. The reason assigned, we don't find it in consonance with our decision of this court. You come to page 19, second para. What's your name?
M.R. Sodio. M.R. Sodio.
Please say again. MR.
Sodio. S-O-D-I-A.
ভিডিও কনফারেন্সে আরে মাইক
Show করে দিও। MR Sudial, Counsel for the Petitioner. For the Home Department, is A. Varma. Your name? Yes. HP. On behalf of the Council for the Lieutenant of India, Mr. P. Sharma, Government Advocate appearing for the respondent number 4. Ms. Balram will be for 2, 3, 5. Page 4, para 2, opinion dated so and so, in so and so. Notice, extra copies within 2 days. Call for the records. Bill to the satisfaction of
SP Bongaigaon.
the Badal Mohammed.
Deeply obliged.
Item 6.
इसको close कर दियो. Video.
ইয়ারে মাইক বন্ধ করো না না
नहीं video तो off कर दो.
ভয়েস টু সাউন্ড
Video तो off कर दो. Video तो टाइम ऐसे तो video off कर दो. Side করে দিও না, ভালো লাগে। Yes, item 6.
I'm sorry, my lord.
What is your link documents?
My lord, the petitioner for the first time casted vote in 1977, but 1966 voter list, my lord, fathers and brother are available, my lord. Page number 14 may be seen, brother's name, my lord, along with father. Page number 14. Miyaruddin is the father and his own brother Nurul Haq. But at that point of time, his age was not completed. Page 66 and 71 voter list, my lord, page 14 and 16. Lordship, my lord, the petitioner's name, my lord, page number 18, vernacular, page number 19, my lord. This is a document of 1977. Vernacular may be seen, my lord, page number 19. The family member's name and the casted vote, my lord, and the petitioner's name appeared at serial number 4, Nur Islam, along with his father, Miyaruddin. Thereafter, my lord, up to 85, as per the office report of the district election office, my lord, no voter lists are available, for which, my lord, the petitioner could not annex and could not find out. Page number 20 is the report of the election office, my lord. Page number 20, up to 1985, some voter lists are not available, my lord. So he could not. And thereafter, my lord, he annexed all the voter lists, my lord, from 1989. Page number 21 onwards, my lord, his name is clearly seen in the voter list along with his father, my lord. Page number 21, 1989 voter list, my lord, and thereafter, my lord, his name is being appeared in the all voter list up to 2015, my lord.
What is your written statement?
My lord, the written statement, I could not obtain the certificate copy, my lord. I have annexed the evidence of PW 1 and 2, my lord. Lordship, may kindly see page number 40, my lord, 40. 402 is the petitioner. Page number 42, my lord, he has stated in paragraph 11 and 12.
Now,
my lord.
where is any voter list showing the all family members there? You
Voter
said
list,
that you have brothers, sisters and all.
yes, my lord.
Any
One of
voter
the
list?
voter list, my lord, lordship, one of the voter list, my lord, page 1977, page number 18. This was, my lord,
Page number?
page number 18, my lord. 18 vernacular, 19, my lord, all the family members. And my lord, from 1989 at page number 21 may be seen for a moment, my lord. Page number 21, vernacular. Page
19
number,
is not a voters list. It's not admissible.
My lord, the certified copies, my lord, from page number 23 onwards, my lord. Page number 23, my lord. Vernacular 24. Some of the voter lists are not available in the office, my lord, so he could not obtain, my lord. Page number 24 may be seen, my lord. Voter list of 1993.
You filed your WS.
Yes, my lord, I filed, my lord.
You did not annex it.
I could not obtain the certificate copy, my lord, so. My lord, I am having the photocopy only, my lord, the certificate. I could not upload the WS, my lord.
Cross-examination is also not there.
Course examination, my lord, in the district of Dorong, my lord, the office, my lord, doesn't furnish the copy of the cross examination. Thereafter, my lord, we applied, but the same was not furnished to us, my lord. Only the documents are.
Have you made that statement in your writ petition? Have you made that statement in your writ petition?
No, my lord,
No,
I have not
then-
stated, my lord. My lord, I have obtained the photocopy of the written
Because we
statement.
don't know, we don't go to every FT and then find out how copies are given.
My lord, I am sorry, my lord, WS, my lord, I could not obtain.
Because your story is not matching. You say that your brother was Noor Islam, then it is Noor Haq.
My lord, lordship may kindly see the evidence of DW 1 and 2, my lord.
DW one we have seen your brother did not come and depose in your favor.
Father did not come, but the one villager, my lord, 87 years old person, my lord, friend of the
age-
father.
Age has got nothing to do. He's not your family member. How is the opinion of a third party relevant? You see,
One
you're a smart young
government,
man.
The
You are a smart young man. Maybe all your friends call you by the name of some movie star. Let us say Sylvester Stallone, everybody calls you. Doesn't make you Sylvester Stallone. There must be something to show, something to connect.
My lord, so far the link is concerned, my lord, I have annexed one Gavura certificate. Her father's name is there, my lord.
Gawra did not come and depose in your favor.
So there's some,
So you've got nothing in your closet.
my lord, I exhibited, my lord, the PAN card and voter ID card where my father's name is there, my lord.
You know, do we have to tell you about the law laid down by this court regard to PAN card? These things are already well settled. You will have to tell us something very substantive.
Yes. Right.
You get certified copies and give it. If you are not getting it,
Make a
you
statement.
make a statement here. You get
Right.
copies, your
May-
written
May I
statement.
pay for, call for
At
the
least.
LCR, my lord. Maybe.
We are not here to make it things easier for you. You apply, you get copy.
My lord, I will
Show us.
obtain.
It is your case to
My-
tell us.
I will obtain.
You have made a statement that you have applied for certified copies, but it has not been granted.
I will file an
Submit it.
evidence. My lord.
There is no statement. Right.
In the meantime, my lord, I may be protected in near about 70. or
You
so
first
percent.
complete your pleadings.
My lord, I will.
First complete your pleadings.
Also, it's represented on the prayer made by Mr. A. Ali, London Council for the petitioner, list after a week, so as to after a week,
A date may be fixed, my lord.
list on 21/8/2024.
Item 7.
May I plead your lordship? See, impugn order at page 76.
76.
My lord, earlier the petitioner was declared as foreigner. Thereafter, that order was silenced before this honorable court. Then this honorable court set aside the impugn order and remand back the case. Thereafter, petitioner appeared before the tribunal below. Again, she was declared as foreigner by order dated 2/3/2023.
Where is the opinion?
Opinion, my lord, page 76.
Same. What is this to discuss? Even certificate. Page 81. 81. Last paragraph. Ms. Varma will have to admit it and call for the records. This opinion itself, again, you come to page 81. Last para. Yeah. Where is exhibit K?
Exhibit
Which
K-
page?
As exhibit
K.
K, exhibit K, exhibit K, page 105. Final Khatian. On the first. Our grandfather's name is appeared at serial number 4. Danish Sheikh.
We are not interested in the names, we are interested in the date. What is the date of this Khatian? Page 97. The date is not readable. You must show some document prior to 66 or prior to 25,
My lord,
71.
in page number 107,
Yes.
bottom 8 to 1962.
We can't read that. In your translated copy, you are not given the date. You see, if you don't give a date, you are not taking responsibility of what you are making a statement. 62, you are saying by orally, but you are not taking responsibility of that. You are not certifying it to be true. And the only document is your school certificate. You did not call the headmaster or headmistress to prove the document.
My lord, headmaster was called for.
Where is this evidence?
My lord, kindly see the
page 62.
62.
Headmaster Gulzar Ali Sheikh was examined.
He did not issue the certificate.
Where is that page? 62.
60. Translate.
63. He deposed his DW3.
It does not prove anything.
My lord, here in his statement, he said,
I am working the head teacher. I have not issued the certificate as per admission register shown as similar.
similar.
But what does it say? We don't know. What is similar? I don't know. But I cannot verify the certificate as I am not the author. Admission register or exhibit co. I do not know so and so. So that entry itself was not proved by you. Today I bought the school register. After exhibition, tribunal returned back the admission register. So therefore, there is nothing on record to show you proved the entry.
Certificate was telling with the admission register.
No, telling is something else and proving an entry is something else. You see, nowadays in a housing complex, there may be two buildings, which is similar to one another. If two houses are similar, you can't say that my flat is in house number 1 also, flat number 1. And in house number 2 also, building number 2 also, my house is flat number 1. You can't claim two flats just because it is similar. Similar and same is two different things. It's a question of citizenship.
The name of the petitioner was appeared with his parents also in voter list 2010 and 2017.
2010.
10 and 2017. 2010 voter list at page 98.
You see, that doesn't help you. 2010 doesn't help you. The reference was initiated in 2007. That means this is a post-reference document. 2010 doesn't help you. Anything to show before 2007. You were born in 1980. Your school certificate goes, now what is this Kabir Nama?
Kabir Nama.
So shows that Kabir Nama. Who, did the Qazi come?
No, my lord. Kabir Nama was not examined. Qazi was not examined.
Where is that document?
Kabir Nama is my lord. No, not exhibited, my lord.
Not exhibited. No, it has been exhibited. Your opinion says so. Huh?
Not in the repetition.
Oh. So complete your pleadings, you show us the document. In the opinion I read, somewhere Kabir Nama is mentioned. But I can't find it.
Page 79,
Ah.
document submitted by.
Kabir Nama, Exhibit J.
My lord, I have stated at para 23 at page 70.
Page
At page 17.
70.
17. Para 23.
I have stated here, but the said Kabinama had been executed as J. The same is on record. I have not annexed it.
It can't be a record. You bring it, let us see the document. If it satisfies us, then we admit it. All sides, both sides are represented on the prayer made by land council for the petitioner list after a week.
I mean,
After the 60 days.
After a week. If it's a
Interim-
date, then 21st, make it 21st,
my lord.
21st of August.
Interim.
No.
Next date.
We are not even have the documents. You withhold the documents and then you ask for an interim.
My lord, I have annexed the, I have also annexed the verification report. Nothing has been recorded there.
We'll come to it. You take a chance. We'll take it up again. You take a chance. We then decide, on merit.
My lord.
You take a chance.
My lord, the date may be fixed.
We are giving you a date.
24. Thank you.
Supplementary item 43.
Yes, Lord. This is a contested case, Lordship. Opinion at page 23, Lord.
What is the document to link you to with your father and grandfather?
In Lordship, though Kavinnama was executed, Lordship, but during the trial, the Kazi was not examined. Though we have annexed this Kavinnama. And so far the linkage is concerned, Lordship, in support of her linkage, petitioner's cousin, petitioner's paternal uncle, who had casted vote along with the father and Panchayat secretary, Lordship, were examined, Lordship, and their evidence we have annexed.
Where is your written statement? Where is the written statement?
Written statement, page 77.
77. Who is DW2?
DWP's mother, Lordship, during the trial, Lordship, petitioner's mother was expired, Lordship. Accordingly, he was not prosecuted.
Okay, then who is DW3?
He is a cousin brother, Abul Qasim, cousin brother,
Where is his evidence?
page 100.
100. You see, you are not giving good evidence. You say that your
Lordship, page 98 may be seen, Lordship. He is the paternal uncle of the petitioner who had casted vote along with his father, Lordship, in the year 1977. Page 98, evidence of paternal uncle of the petitioner, Lordship. And voter list of 1977, we have annexed, Lordship. That is page 46.
any voters list of your father and mother together?
Yes, Lordship.
Where is that?
1979, Lordship, that is.
Which page?
It is page 50, Lordship.
50.
My paternal uncle's name is also mentioned, serial number 460,
Just a moment.
page 50. And in the total.
Just a moment.
Mother's name. Page 52, Lordship, sorry, 1989. Mother's name. Page 52. Page 52. Azimuddin Razia Khatun. Annexer 6, Lordship.
Something like that, what is that? Actually. Any other voters list of your father and your mothers? There are your two mothers you have.
Lordship, what happened, Lordship, after solemnization of second marriage of my father with Momina Khatun, my own mother, Lordship, left my parents' house, Lordship. We have
But
mentioned.
then nothing is matching. You see, you are showing us page 50. You have given the name of your mother there.
52, Lordship.
Serial number 50.
52, 52.
No, what is 50 then?
That is 79, Lordship.
So whatever is, we are showing you
59,
one.
52 may be seen, Lordship. Azimuddin Razia Khatun.
No, you can't. You see, come to page 50, serial number 414, there is a name. This name does not tally with 52. It also does not tally with page 79, para 8. You have disclosed a name here in page 50.
Lordship.
This 50 does not match with 52. It also does not match with para 8, page 79.
So we have applied certificate to sometimes, Lordship, we have applied in the name of Azimuddin, Lordship. For example, Lordship, kindly see page 77, Lordship. Lordship, kindly
No,
see
you must give your statement. We can understand there is a
Yes,
spelling mistake, but you must show that in your written statement or in your evidence.
Lordship, kindly see page 46, Lordship.
Page
46.
46.
Yes, Lordship. Annexer 4. Yeah, serial number 429. My father name was shown to have recorded. 430, my paternal uncle's name. Page 46. page 46,
Yes.
49, 429 Azimuddin and 430 Moizuddin Lordship. And certificate copy may be seen page, next page Lordship in particular page 47 may be seen. Azimuddin Moizuddin Lordship, duly recorded Lordship. Now kindly see page 48 Lordship. In the same voter list Lordship, when we applied for certificate copy Lordship,
But
my,
you see,
my grandfather name was not recorded in the
oh,
certificate
that's
copy.
okay. But you see, you are showing us something. Please compare it with page 98. In 98, your uncle says,
Lordship.
Mahiruddin Sheikh, son of late Maser Ali. Maser Ali was not the name of your grandfather.
Yes, Meseruddin.
Maseruddin and Maser Ali, again.
Lordship, some is there, Lordship.
No, where is your statement in your written statement? You must show us something. That
Lordship.
you made that statement and then the court discarded it.
Lordship, I am saying, I'm showing Lordship in written statement. That was discrepancy was mentioned in the written statement also. Yes,
So that.
page 78 maybe, sir. Page 78, para 7.
Yes, we are there.
Para 7. That the opposite party's grandfather Meseruddin Munshi alias Haji Meseruddin alias Meseruddin Sheikh. Meseruddin is common Lordship. Sometimes it is Meseruddin, sometimes Meseruddin Munshi. This
No, that
discrepancy
is
is there, Lordship.
no. Your uncle comes and says Maser Ali. Page 98.
Is
Because you see, when we read these things,
actually
there are many things
that
which
Meser Ali was recorded by the tribunal, Lordship.
we don't know.
In oath, Lordship, on oath, Lordship, he duly mentioned the name of the petitioner's father as his brother, Lordship. Azimuddin is there, Lordship. Lordship, Meser is common, Lordship. Something Ali, something that is discrepancy is there, Lordship. I am admitted. So for the 1966 voter list, Lordship 77, all the voter list Haji Meseruddin is there.
Where is your examination in chief?
Lordship.
Where is your examination in chief? This is cross. Where is the examination in chief?
Lordship, petitioner's Lordship.
No, that page 100. No, not 100. That 98.
Okay, evidence is that is written in the form of affidavit, Lordship, that we have not annexed, Lordship. In cross part is relevant, Lordship. I have filed it. That evidence.
No,
is
that
Lordship.
you don't tell us what is relevant, what is not
Yes, Lordship.
relevant.
And
Now, something which is not relevant, for that your case will be adjourned.
Lordship, and so far the Lordship petitioner linkage is concerned, that is also established
We-
through
we
consent
complete your-
certificate
you
also.
see, please complete your pleadings and then come to court. Don't think what is relevant, what is not relevant. Let that be left open to the court to decide.
Yes, sir. I have annexed the evidence of my mother also, Lordship. Yeah. Since he died, Lordship, during the trial, Lordship, I have annexed his evidence in chief, Lordship.
You see, you are making us
mother-
read page 98. You said your father had two wives and you are the only child. Correct?
Yes, Lordship.
Your uncle also says that you have landed properties, but it was not mutated in your names. Neither their names it was mutated. It's a inherited property.
Yes, Lordship.
Why would somebody not mutate the name after your mother died? After
Land is Lordship, share was given to the petitioner's Lordship, but that was not mutated. Share was given to the petitioner, that was not mutated. Not recorded in the name of the present
how can you say
petitioner.
that? This is not a part of pleading.
Yes, Lordship.
You are making a statement before the court What is your instructions on that? You better bring it on record. Don't,
Lordship,
you bring it on record. The missing documents, bring it on record.
Lordship, evidence of Lordship,
Whatever is there missing, I don't make a note of what is missing. Whatever is missing, you please bring in.
Lordship, almost all the documents we have annexed, Lordship, except some evidence, Lordship.
So what we are asking is not there.
Lordship, till then I may be protected, I may be allowed to file
no,
additional
no.
affidavit, Lordship.
You bring it on record, you do it tomorrow, we'll take it up tomorrow. When do you want?
Any date, Lordship.
You tell a date, we'll give you a date of your choice, except Monday. Monday, we have a fixed matter. You choose a date, we'll give it on that day.
Twenty-eight, Lordship.
2/8.
2/8.
Okay, this one 2/8/2020. Oh, as prayed for by the counsel for the petitioner. Both sides are represented.
Item 9 for admission.
May please be watched.
Yes.
But in this case, this is complete matter. So Lordship will take up the matter for final disposal on next Tuesday, my lord. Not FT matter, my lord.
Pardon me?
This is not FT matter, my lord.
I understand.
Lordship will take up the matter on 20th, my lord, for final disposal.
It's 18 matter, we can take it up today also, if you are ready.
Mr. Natri is not there, my lord. He was supposed to appear from the
Huh?
government side.
Srinath is attending the matter. Another date may be fixed for hearing. Reading the documents completely.
But you see, you have made out there's one part of which is pleadings. In your prayer, you only say that to give protection, to pay compensation.
Yes, ma'am. He was a minor at that time, my lord, when he was detained in the police custody, my lord. He was inflicted injury, my lord, for which, my lord, he has become, my lord, partially disabled.
In the inquiry, fact-finding inquiry, it was found that the private respondent herein, he was found to be involved in torturing the petitioner's son.
Okay. When do you want? Both of you agree to a date?
On 20th, my lord. On next
28.
Tuesday, my lord. 20, my lord.
20.
My lord. Next Tuesday. My lord.
Okay. Both sides are represented. It was agreed to by both sides. List on. Now, on the joint prayer made by learned counsel for both sides. List on 208-2024.
Obliged, my lord.
Item 10.
There's no representation by the petitioner. However, Ms. A. Verma, and a standing counsel for the Home Department representing respondent numbers 2, 6, 2 and 6 are present, 2, 6 and 7. No, make it 2 and 6, comma. Mr. P. Sharma, the government advocate, appearing for respondent number 5 and 7. Election Commission was there. Mr. H. Kuli, appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 2, and only 2 are present. Next para. The petitioner has remained unrepresented when the matter was previously listed on 27/5/2020, 10/5/2023, and 9/10/2023. Post-op. Accordingly, it appears that the petitioner is not interested to pursue this matter. So accordingly, this writ petition stands dismissed for non-prosecution.
Item 13.
Normally, Mr. Viswas is there. After some the Passover.
Item 14.
Yeah, please, Your Lordship. My lord, the matter may be adjourned for the day my senior advocate could not appear today due to his illness.
List after a week is paid for by, both sides represented. List after a week is paid for by land council for the petitioner.
My lord, after 2 weeks, if possible, after 2 weeks.
2 weeks. Okay. The LCR is coming. Okay.
Let's know.
Item 15,
2 weeks, huh?
May it please your lordship. My lord, can it be next week, my lord? Because this lady was seriously ill earlier, my lord. Whether
Pardon?
this petitioner is earlier seriously ill, my lord. So I have not taken any instruction, my lord. I try to contact, my lord. She was enlarged on bail. And thereafter, my lord, record also come, my lord.
Yes, make your submissions.
My lord, I pray for time today, my lord.
This has come up after 4 years, 3 years.
It's a matter of 20, my lord.
No, after 21, after 3 years it has come.
Yes, my lord.
You see, 2 documents on which you are relying,
Lordship.
the tribunal has discarded it. And we found that it's not for reasons we can interfere. Your document is the school document, transfer document and your marriage certificate.
Yes.
Both are not proved.
But one Gowda certificate is there, my lord. Gowda also examined. And my lord, her elder brother also examined, my lord. He is aged about 57 years. And so far, brutal lists are also there, my lord. Parent, father brutal list from 1996.
No, but you see this, the Gambura certificate is exhibit 11.
Yes, sir.
It has been discarded because it is not based on contemporaries record. And you know about the case, law settled by this court in that regard.
Yes, sir. But Gowda stated that he knows.
He doesn't maintain a record. Therefore, he can't make a oral statement
So I will argue, my lord, kindly today, my lord.
No, after these two documents, there is nothing more to argue.
Brother, my lord, repose before the court, my lord.
The witness who came was Ang Rashid.
Yes, Abdul Rashid.
He's not from the same village.
My lord, witness, my lord, the Abdul Majid, her brother, my lord. And Abdul Mateen is her, my lord, husband. His husband, my lord, another village.
Pardon me?
Abdul Mateen is the husband. My lord.
No, who's A Rashid?
A Rashid, my lord, is my father. Abdul Rashid is my father.
But it does not belong to your village. Neither he is from Bedoti village nor Ira Kapli village.
My lord, last may kindly see page 45, voter list, my lord.
Page 7.
Village is
Voters list of
1966.
1960. No, we are in 1993 now.
Voter list 1993.
Shows something 1993.
Yes, my lord.
It's a different village.
Jaida Khatun. Here, husband name is there, Abdul Mateen, my lord. The village is Era Kapili.
What is your name?
Jaida Khatun. Lakshmi, kindly see page,
Zaida Khatun.
yes, page 59, my lord. This will be clear, my lord. First, Abdul Mateen is husband, my lord. Next, Jaida Khatun, wife of Abdul Mateen. So I think, my lord, in 1990, some discrepancy is there, my lord.
But how is it relevant? You see, it's the same year, 1993.
Yes.
1993, your husband is in village, page 56. He is in village Bhadovati.
Yes, my lord.
Correct. In the next voters list of 58 of the same year, 1993, he is again in a resident of different village. You are of different village, Abdul Latif. It is in village Era Kapili.
No, my lord, Abdul Latif.
Page number 50, 53. Jaida Khatun, Abdul Mateen, Era Kapili. There's nothing there in the.
Some discrepancy is there, my lord.
I'm looking at the page 54, Assamese version.
Page 50.
Same thing. Abdul Matin.
65 years. First name, Dr.
So that's why we started from 1993.
Malad,
The village also changes and the names also keep on changing it with every voter.
I'll take instruction, Malad, in this regard.
Hmm?
I'll take instruction in this regard. Why this-
No instructions. Whatever is there is available in the writ petition.
Yes, Malad.
Again, the husband's name becomes different. Jaida Khatun, wife of Abdul Latif. And she claims Abdul Latif to be her husband.
He must be in competition with.
Malad. Page 32 is her statement, Malad.
But it doesn't match.
In respect of husband, Malad.
No, we forget that she may have what you call her marriage with A, B, or C is not relevant. The relevancy is that she should make and stake her claim through the father.
Yes, Malad. Father name appeared in 1966, Malad.
But then everything else fails.
Malad, father name is Abdul Rashid, Malad. Father name is Abdul Rashid. Malad.
But with that, you have no connection. You'll have to tell us a link. You show us a document and then link it to your father.
Link, Malad, government certificate, Malad. which was
Government
like-
certificate is
And one is, Malad, school certificate. But that school certificate, Malad,
Gabra is not with contemporaries record. There is no material here.
and another, Malad, that school certificate, Malad, transfer certificate. Malad.
School certificates are not proved.
No, it's not proof, Malad. Headmaster was examined, Malad. But he said that some luster will find.
It's 75 years.
75.
Masters. No record on this page. It is at page 75. It will get one school certificate issued by me in favor of opposite parties when she authorized me.
So he's changed over to his personal knowledge.
Yeah.
From school records, he said the school records are not there, but I personally know.
Yes, that is there, Malad.
Then
So luster will fix it any other day, Malad. I tried. No, Malad, I am beginning, Malad, prayed for some time.
okay, we are giving you time till Friday.
Plus.
Both sides are represented. This term, Friday. 16-8. As paid for by the counsel to the petitioner.
Obliged.
Oh, we'll take a break and come back.
Able Lordship. My lord, may say the impugn order page 77. My case was mainly dismissed that I was declared as foreigner, that no valid documents or admissible documents were exhibited. Now,
Shows this exhibit G,
yes,
shows the exhibit G.
yes. Kachapatta of the year 1959 and 60, page 20.
Shows that, page 20.
Yes, 20.
Did you prove the certified copy of the Jamabandi?
36, that is 36, my lord. Now, I think it is proved, otherwise it would have been recorded in the judgment. It may be seen only on the LCR. Jamabandi, page 36.
36.
And there is the seal of the circle officer.
No, just a moment. This is in whose name? This Kachapata?
Hussain Ali, my father's name.
Hussain Ali. Now in Jamabandi, where is that entry?
Jamabandi,
Hussain Ali.
that page 36, serial number 5.
Where is your written statement?
Page 45.
Nasrin Ali Hussain Miller. Mr. Sharma, we're keeping it for hearing because there appears to be good ground. You've seen the LCR? You go through it. We take it up next Thursday, 22nd. Both sides are represented in view of the issue raised in this writ petition. The writ petition is admitted for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. Next one, as the LCR is available, list the matter for hearing on 22/8/2024. 27. Okay, 27. 27th.
Item 18.
Number 28. None appears. However, all the respondents are represented. For ensures justice, the matter stands adjourned today. List after a week. Just a minute. Mr. Das will upgrade your matter and release you. Item 28. 26. Yes, sir. 26, 28. We'll upgrade it and release it.
Item 26 upgraded.
How you have linked to the father and grandfather?
Father is Fazor Ali, my lord. And mother is Kendi. And she was married to she was married to Procureur of village Babora. Now her father and mother were recorded as voters in 1965 and 70, my lord. And
'65. Where is that voters list?
my lord, he has got a land record, my lord. It is Annexure 18, Jamamandi, and he had purchased one plot of land in before 2000, and there his father's name appears. So he is Fazor Ali Fakir is his father. It is proved, my lord, and Fakir.
What is the
Fazor
name
Ali
of
Fakir
the?
and Kendi
No, you
are
are
recorded
showing
as
where is
voters
the first voters list? 1965. Where is that?
65 and 70, my lord.
This is Fazor Ali.
Fazor Ali Kendi.
Fazor Ali is your father. Grandfather is Mia
Box.
Box.
Yes, my lord.
Now this page 18, you are annexure 18 you are trying to show.
Yes, my lord.
Where is your Mia Box Fakir? And how did you prove your heritage to your father?
No problem,
Kabinama. How did you prove your that you are this Fazar Ali and this and your projected grandfather? How did you? Yeah, Box Fakir. How did you prove that Fazar Ali is your father and Mia Box is your grandfather? You have any voters list together?
my lord. My lord, in voter list of 1997, the name of Jamila, name of Abdul Jalil, brother of Jamila, my lord, he has been examined as PW2. This Abdul Jalil and his mother Kotbanu were recorded as voters. And this Kotbanu is the wife of Fazar as per voter list of 65 and 71. That is the linkage, my lord. This Mia Box, grandfather of Jamila, my lord, he had got landed property since 1937. And That Jamapuria
Just a moment,
exhibit.
just a moment. That's this 1997, which you are showing us at page 60. There's a mismatch. You're saying that this is the document which establishes your linkage. But 1997, we are finding it mismatch. Here at page 60, the first name is Abdul Jalil,
Yes, my lord.
son of Fajar.
Further,
That means, who is this Muhammad Jalil? Sorry, A Jalil, who is he? Who is A Jalil?
Jalil is the brother of Jamila.
Jalil is the brother.
He has been examined as PW2. BW2, my lord.
So he is with your mother.
Yes, ma'am. Kodbanu is my mother, is her mother. And Kodbanu is the wife of Khajor.
Is it
who is
same
the father
village?
Father of.
Is it same village? Where the land is situated?
Yes. No, my mother. This Jamila was born in Amlaki, but she was married to.
No, in 97, your brother and your mother resides in village
Amlaki.
Sorai Joria.
Sorai Juria, madam. Then she shifted to Sorai Juria. They shifted to Sorai Juria afterwards, my lord.
Where is your written statement?
Abdul
Page 13.
Page 13, my lord.
Have you stated about your brother here? The existence of brother is not here.
Oh, yes, ma'am. My lord, the learned tribunal has pointed out that in the WS, petitioner did not mention that further his brother.
Yes.
And only for that reason, he disbelieved that other tribunal disbelieved. But that was not mentioned, my lord, that he is the brother. It was not mentioned in WS. And for that reason, along with that he did not mention his date of birth and place of birth in the WS. For these reasons, my lord, the learned tribunal disbelieved the evidence of Dhamela and said that she is an illegal migrant of post 25th March 2007, only for these two reasons.
Affidavit, page 20. 1 second. I have 4 papers. No question. No question. No, date লিখিছে। মিস্টেক আছে। মিস্টেক আছে এটা। এটা কোন ডিপোজিট? Process it.
ভারতের স্বাধীনতা আন্দোলন রাষ্ট্রকাল বঙ্গালী চেষ্টা করেছে এগুলো তেওঁলোকে ৰেফিউজি হৈ ইণ্ডিয়াতে আছে আৰু অসমত যিবিলাক আহিছে
You have anything to say to support the opinion?
You want to go through the, have you gone through the records? Have you gone through the records? No. Through the records. It appears to be a case where we may have to interfere with the prima facie as it appears.
You see what has happened. You go through the records, that will be necessary. The land document was discarded on the ground that the entries are wrong. Correct. But look at the evidence of the witness. He comes and says that the entry is wrong, but we gave the certified copy. If the authorities are giving a certified copy which is wrong, why would he lose the citizenship? You look at the cross-examination of examination and cross-examination of the witness DW3. Page 45 is and the original is in 46. And we have to discard his statement of this second part of his examination. The land was mutated in the name of one Munka. Correct. In Assamese also he says the same. Assamese version, you find it page 46A. মুনকা বুলি এজনৰ নামত নামজাৰি হয়. Correct. But look at this page 66. Mia Box Fakir. So that part of the evidence has to be discarded. You go through it because that's why we are. And Mr. Das, there are certain typing error in your translation. That made us read documents here and there to find out. From Assamese version to English, there are typing errors. Your husband names is wrongly written. And the, what do you call, in a lighter side, can we ask you, do you believe in life after death? I'm asking in a lighter tone. Do you believe in life after death?
After that, life cannot be believed, my lord.
Not believable. Then you are right. Because in your in the examination chief of typing where you have made, you have written the name of your brother as late, but then he came and deposed as DW3, DW2. Your third brother was dead, but instead of that, you wrote against your second brother as late. That is why we are asking you that question. Okay, you examine that. Both sides are represented. Mr. G. Sharma, learned counsel for the Home Department. Please to give him some time to go through the trial court records. Prayer is allowed. List on 22nd August. In his next matter also, we have gone through the records. 28. You have seen the records? Okay, same order in item 28 also. You are adjourning it. Let him go through the LCR.
My lord, I've got another 128 item number.
Same
And this is-
Same day. We're fixing it.
Item 44, for orders fixed at 2 p.m.
So, my lord, this is a habeas corpus petition on the last occasion. The issue which came up before this court was with regard to the maintainability of this instant petition, fact being that the detention is through a court's order, and whether a writ of habeas corpus can be issued against a detention which is through a court's order. That is the moot question, my lord. So, my lord, I have gone through, my lord. I have also tried to find out whether such similar situation is there, but no similar situation could be found. But the principle is that a writ of habeas corpus can be issued when a detention is by a court order, but there are certain conditions. The detention order, the court, before issuing a writ of habeas corpus against a court order, the court has to held that the detention order which is passed is without jurisdiction, or is absolute illegality, or has been passed in mechanical manner or in casual manner. If these conditions are
No,
satisfied,
Mr. Khan, you see, when we normally speak of a detention order, first which comes to the mind is detention order under NSA, detention order under the PTS and NDPS Act. Those are done by the authorities. But here what has happened, that has been ratified by the court.
my lord, will not say detention
So
order,
judicial,
it simply says
judicial
order.
order, because against a judicial order, you have a remedy of revision or appeal. But insofar as the normal detention orders are concerned, passed by the authorities, you have a, what you call, a committee to, or a administrative body to look into it. And then the court is the only remedy available.
My lord, I'll refer it to as order, as an order only, my lord, not because I'll place some judgments. Yeah, I do that first, Supreme Court. My lord, I have brought only 3 judgments. One is by the two judge bench of the Supreme Court. One is by the 2 judge bench of Patna High Court, and one by the 2 judge bench of Delhi High Court. Only 3 judgments I will place. Supreme Court decision, no, first Supreme Court decision. 2013 1 SCC 314. It is Manubhai Ratilal Patel versus the state of Gujarat and others. Kindly come to para 31, my lord. The principal is there, my lord. Para 31. Now, my lord, C, my lord. A, B, C, my lord, right hand side, the C column, my lord. It is well accepted. Lordship have got.
Yes, please continue.
Yes.
Please continue.
It is well accepted principle that a writ of habeas corpus is not to be entertained when a person is committed to judicial custody or police custody by the competent court by an order which prima facie does not appear to be without jurisdiction or passed in an absolute mechanical or wholly illegal. So, my lord, this condition that prima facie it has to appear to be illegal without jurisdiction or passed in a mechanical manner and wholly illegal. If this condition is satisfied, then this writ can be issued, my lord. Now, reading further, my lord, as has been stated in B. Ramachandra Rao and Kanu Sanyal, the court is required to scrutinize the legality or otherwise of the order of detention which has been passed, unless the court is satisfied that the person has been committed to jail custody by virtue of an order that suffers from the vice of lack of jurisdiction or absolute illegality, a writ of habeas corpus cannot be granted. But, my lord, if these are satisfied, then it can be granted. That is the principle. Now, my lord, I will place another two judgments, my lord. Already copy has, my lord, I am placing Delhi High Court two judge bench, my lord. That is Nitin Garg versus Union of India and others. Kindly come to para 21. Para 21.
Just a moment.
Lower, because this one.
I've seen the decision after a long time. I forgot the context. This case of Manubhai Ratilal Patel. You see page para 21. How do you reconcile this with your previous argument made on the last date?
Para 21, my lord. The principle laid down in Kanu Sanyal thus is that any infirmity in the detention of the petitioner at the initial stage cannot invalidate the subsequent detention, and the same has to be judged on its own merit.
Because last time you made a submission, your entire edifice on the last date was that the initial order was, initial arrest and detention was bad. And therefore, the court, it validated the illegal order and then put him into custody. That's what your argument was.
My lord,
No, it's not that. I'm just trying to ask you, how do you reconcile your previous argument with para 21 here?
the later part of the order, my lord, validating the detention is also illegal, because at best that is under section 309. But on that day, the accused was not produced before the court. Accused was remanded to I'll go through the order, my lord. By the previous order, accused was supposed remanded to till 18th of that month. Under section, suppose 309, which is illegal. That cannot be validated, my lord, without bringing the accused to the court. Without bringing him, again he was remanded, suppose till 24th. That cannot be done, my lord. If court has to remand him, my lord, it has to be a proper remand. Accused is in jail, write some remand order, which we are saying is illegal, without producing the accused before the court on that day, without letting him know that you are being remanded till next date, my lord, that is illegal, my lord. Any remand by the court has to be in the presence of the accused. Any remand, my lord. If it is after 15 days or on the day of arrest, accused has to be before the court. The accused person does not even know he is being remanded under 309 on dated so and so while rejecting the bail prayer, my lord. That itself is illegal, my lord. Fact being that accused was not before the court. So, my lord, place another two judgments, my lord. There. My lord, I am placing the Delhi High Court, my lord, Nitin Garg versus the Union of India and others, my lord. Para 21. Analysis and findings. Para 21, my lord. Taking note of the submissions which were made at length, pertinently a writ of habeas corpus is an extraordinary remedy where there is illegal confinement violating the personal liberty of a person. Ordinarily, an order of remand by a competent court is essentially a judicial function and cannot be challenged by way of writ of habeas corpus unless and until the remand order lacks jurisdiction or is absolutely illegal, resulting in unlawful custody. It is true that an order of remand can be challenged in a habeas corpus petition if such an order is passed in an absolutely mechanical and casual manner. But this is in my favor, my lord. And my lord, I will just immediately place, my lord, quickly place the Patna High Court, my lord. That is Manoj Kumar Ladha versus CBI. Para 17, my lord. Paragraph 17. In the light of the question that has arisen as to whether the learned special court CBI 1 has passed the order in a mechanical manner and therefore the petitioner is entitled to issuance of a writ in the nature of habeas corpus. So it is held here also, my lord, that if it is in a mechanical manner, it can be issued. Now, para 18, my lord, quickly, my lord. It is evident on bare reading of the order dated 26/10/22 that the same was not passed in a mechanical manner, rather with due application of mind. So, my lord, the court has reproduced the order and have applied its mind that whether this order is without any authority or in a mechanical manner. And at para 18, my lord, the court have held that no, this is not mechanical manner. So, my lord, my humble prayer before your lordship is that lordship may kindly peruse the order, my lord, which we have impugned in this case, and this court may kindly scrutinize whether that order is mechanical, illegal, passed in a casual manner or not. If yes, then a writ of habeas corpus will lie. If no, if the answer is in negative and the court holds, this court holds that no, this order is proper, it is not in a mechanical manner, then the writ of habeas corpus cannot be issued. It is simple.
Where are those orders, pages?
My lord,
The
Starts from
the
Page 49.
transport order.
page 49. See, order dated 6/5/2022. Our submission with regard to this order was that immediately after coming to know that all the cases pending against the present petitioner at the Muzaffar jail is over, the learned court here, my lord, ought not to have passed this order. That is our contention.
Yes.
But see, first, the petition is not maintained alleged because the accused was arrested in course of a regular criminal proceeding under NDPS Act.
You are challenging which orders, page number?
Page number 49, my lord,
49 and
and 88. Order dated
12 seconds.
6/5, first prayer, my lord, at page 21, my prayer Roman small one is 6/5/22, which is at page 49. Then I have put to challenge order dated 12/7/2023 and all subsequent orders issued in custody warrant. That is my prayer, second prayer, and third prayer is to allow to go on bail.
No, second, where is that second order?
Page 88. 12/7/2023. Because when he was produced from that jail, he was remanded. For the first time, he was put behind bar by the trial court at Guwahati. Prior to that, he was at Muzaffarpur or Chhapra jail. Muzaffarpur jail and Chhapra jail.
Yes, Mr. Kale.
May come to page 49. Order dated 6/5/2022. Is being put under challenge.
Yes.
Steve, opening paragraph, accused Pappu Sahni, alias Pappu Kumar Sahni, produced today through VC from Shahid Khusiram Bose Central Jail. So on VC, he was produced before the court. On page 81.
Page
81. 81. Dated 73/2023.
order dated 17/3/2023. Both sides are present. Peruse the bail petition number so and so on behalf of accused Papu Yadav under section 438. Heard both sides. Also peruse the objection petition filed by the complainant side. On perusal of the case report, it appears that the case is registered under section 20(b)(2)(c) 2829 of NDPS Act involving commercial quantity. The learned special PP for the complainant, NCB Union of India, has submitted that there is sufficient material against the above named accused in view of section 37 of NDPS Act. Bail cannot be allowed to the accused above named. After perusal of the materials on record, in the light of the submission of both sides, I find that section 37 of the NDPS Act is restricted, considering the bail of the accused, and on perusal of the case report, it cannot be held that the stage there are reasonable ground for believing that the named accused is not guilty of the offense, and there is not likely to commit such offense while on bail. Hence, the bail petition under section 438 of service being petition will be rejected this day. Then Lordship, order dated 16/3/2024. Again, bail application was filed, page 99. Page 99. 99. All the accused filed bail application with regard to petitioner. Lordship may come to page 104. The page 104. Third paragraph. Submission for accused Papu Kumar Sahni. Lordship. Married. The learned counsel for the accused Papu Sahni has submitted that on 6/10/2021 at about 4 p.m. the intelligence officer NCB Guwahati recorded an information that on the same day, two persons, namely Praveen Kumar and Nanu Babu, would come in container truck bearing number so and so from Jorabad, Meghalaya side, and to go towards Jalubari side. Praveen Kumar and Nanu Babu were trafficking around 440 into 450 kgs of ganja in the said container truck. Praveen Kumar and Nanu Babu were arrested, and during investigation, two other persons arrested. On 2/4/2022, investigating officer submitted offense report against the 5 accused persons, including the present petitioner, present accused under section 8(2), 28, 29, 35, 53, 54, 60, 63, 67, 68, 69 of the NDPS Act. In the said offense report, the present accused was shown as not arrested, arrayed as accused number 5. On 27/4/2022, on the strength of petition filed by the IO, a protection warrant was issued to accused person for his protection from Sahid Khudiram, Post Central Jail, Muzaffarpur, Bihar, and on the next date, that is fixed on 5/5/2022, for protection of the accused. On 5/5/22, the accused was not produced from the Sahid Khudiram Post Central Jail, Muzaffarpur, Bihar. On the same date, the IO NCB Guwahati had prayed for recording statement of the accused persons, present accused person on 6/5/22 was fixed for production of the accused person and for hearing on petition number so and so filed by the IO for recording statement of the accused. On 6/5/2022, the present accused was produced through video conferencing from Sahid Khudiram Bose Jail, Muzaffarpur, Bihar. On the same day, the superintendent of jail submitted a letter to this court stating that all the cases against the petitioner accused persons pending in local jurisdiction of Muzaffarpur, Bihar has been disposed of, and this court may pass direction for transmission of the present accused for his physical protection before this court. And accordingly, this court has issued PW in regard to the present accused for his physical protection before the court, and had fixed 13/5/2022 for protection of the accused persons. On 13/5/2022, neither the accused was produced from Sahid Khudiram Bose Jail through video conferencing, nor any report regarding his transmission from the said jail to Guwahati Central Jail was received, and therefore the superintendent of Khudiram Bose Jail Central was directed to produce the present accused persons on 18/5/2022, as well as submit report in regard to his transmission. On 18/5/2022, the present accused was produced through BC again and again
on 27/5/2022 was fixed for protection of the present accused persons from Sahid Khudiram Bose jail and, and for transmission report of the accused. On 27/5/2022, the present accused was produced through BC, but no report was received. And accordingly, another date was fixed on 10/6/2022 for production of the present persons. And report on 10/6/2022, 24/6/2022, 8/7/2022, 21/7/2022, and 4/8/2022. The present accused was produced from Sahid Khudiram Bose Central Jail through BC. On 18/8/2022, the IO NCB has filed another petition for recording a statement of the accused, present accused person at Sahidaram Khudiram Bose Central Jail, Muzaffarpur. On the said date, the PW was issued with regard to the physical protection of the accused, and Superintendent of Sahid Khudiram Bose Central Jail, Muzaffarpur was directed to make arrangement for transmission of the present accused persons from said jail to Guwahati Central Jail. On 1/9/2022, 12/9/2022, and 26/9/2022. Again, fresh protection warrant was issued to the present accused persons for his protection before this court. The present accused was produced before this court on many subsequent dates through BC. On 17/2/2023, the IO by petition of students operate for issuing a protection warrant against the present accused persons who was transferred to Chhapra Central Jail, Chhapra, Saran. Thereafter, on many subsequent dates, PW was issued to produce the present accused persons. Bail petition number 1389/23 was filed on behalf of the present accused persons under section 438 was same was rejected. On 12/7/23, the present accused was produced before this court from Chhapra District Jail, Saran by SI Madhav Yadav or Chhapra Richard Kendra on the strength of protection warrant issued against him by this court. On the same day, the intelligence officer CK Singh has filed a petition praying for remanding the accused persons to NCB custody for 3 days, which was rejected by the court, and have remanded the accused persons to judicial custody till 19/7/2023. Since 12/7/23, after his protection before this court, the present accused is in judicial custody. During the investigation of the case, the present accused was never arrested by the investigating agency. The present accused filed an anticipatory bail application being number so and so before the Honorable Guwahati High Court for pre-arrest bail, who was approaching arrest in connection with apprehending arrest in connection with NDPS case number 73/22 corresponding to NCB crime number 28/22 under section so and so of NDPS Act. But by order dated 8/2/23, the Honorable Guwahati High Court was inclined to close the said application for pre-arrest bail of the present accused persons with the liberty to approach before the jurisdictional court and apply for bail in accordance with law. There were 4 numbers of cases pending against the present accused persons, namely Daryapur PS case number so and so, Motiari PS case number so and so, Motiari PS case number so and so, and Motiari PS case number so and so. The present accused was obtained bail in all these cases.
Just a moment.
ডকুমেন্ট করে আসছি Yeah. Because I was spoken and forward leading 165.
Lordship, this was the reason seeking bail and ultimately their submission was that the arrest was illegal. Now Lordship may come to page 109. Objection submitted by the NCP. This will clarify the entire position. Page 109, third paragraph. Bail objection against accused Papu Kumar alias Papu Kumar Sahani. The complainant NCB has stated in its bail objection, accused Achal Sahani alias Akshay Sahani has stated in his voluntary statement that since about last 2 years.
You are presently reading which page?
Page 109.
Yes.
Bail objection against accused Papu Yadav. Papu Sahani. The complainant NCB has stated in his bail objection, accused Alchulal Sahani alias Akshayal Sahani has stated his voluntary statement that since about last 2 years, he was involved in trafficking of ganja. He used to contact with supplier and receiver of ganja. He disclosed the mobile number of receiver, Tuntun Mahato, Amit Kumar Mahato, Papu Kumar Sahani, present petitioner. The truck driver Praveen Kumar and driver Papu Singh, Nanu Babu Mahato, supplier Pradeep and vehicle owner Gurbir Singh. He stated that 426.90 kg of ganja was supposed to be supplied to Tuntun Mahato, Amit Mahato alias Amit Kumar Mahato and Papu Kumar alias Papu Kumar Sahani of Bihar. He identified the photo of Papu Kumar alias Papu Sahani, CAF and CDRs of the mobile numbers which was given by accused Achal Sahani alias Akshay Sahani was analyzed and found that mobile number so-and-so is registered with one name Papu Kumar. During investigation under section 67 of NDPS Act was sent several times to Papu Kumar Yadav, Papu Sahani, above Papu Kumar Sahani. It was learned that from the intelligence officer and Zonal Unit Patna that accused is still in Muzaffarpur Central Jail. To confirm his message, the SHO and page 110 lots. During investigation, notice under section 67 of NDPS Act was sent to several times to Papu Kumar alias Papu Sani and Papu Kumar Sani. It was learned that from the intelligence officer, Journalist Patna, that the accused is still in Muzaffarpur Central Jail, Bihar. To confirm this message, the SHO of Motipur PS, Sri Mahesh Kumar, was contacted, and it was learned that Papu Kumar Sani and Papu Kumar Sani is in Muzaffarpur Jail by Motihari PS case number 4922 dated 5/5/2022 under section 272-273 IPC and section 30A of Bihar Provision of Excise Act and Motipur PS case number 195/21.
Mr. Kyal,
Lordship.
we have a query.
Lordship.
What is, which page is the order by virtue of which your arrest was accepted by the trial court?
Lordship. Lordship, we come to page 114.
114.
Lordship. Decision and reason for accused of Papu Kumar Sani.
Yes. 114.
Lordship, particular
One one five.
115 Lordship.
Today only as a.
Lordship, subpara 3. We may read from paragraph 1. It is clear that NCB has moved required prayer before the court to son arrest accused Papu Kumar Sani in this case, but through inadvertent oversight, order was not passed on the same by my predecessor. Hence, as per records, the accused Papu Kumar Sani was not shown arrest in the case, though the prayer is from the NCB for the same. Today, the prayer for shown arrest of accused Kumar Sani is allowed and petition number so and so dated 2/8/23 is disposed of. Again, as per the learned counsel of the accused Papu Kumar Sani, as the accused got bail in all cases of his home at Bihar in Chapra jail should have been released him from jail and should not have detained him only due to production warrant against issued by this court. This court has nothing to say regarding any irregularity done on the part of Chapra jail Saran. Now question is that the present state of accused Papu Kumar Sani is in this case is that he is not shown arrest in this case does not entitle the accused to bail as argued by the learned counsel for the accused Papu Sani. It is considered opinion of this court, the accused not automatically get bail due to any irregularity in case of serious offences committed under NDPS Act due to sufficiency of materials against the accused Papu Kumar Sani. This court has framed charge against the accused Papu Sani has criminal antecedent. In view of the reason discussed above, the prayer of the accused is rejected.
Just check this scan copy. This petition number 424A, whether it is here or not, please try to find out.
424 ML. Anasana,
Five to four.
524.
524.
that, Or you have a copy there in your petition?
I think this is scan copy of the LCR. I'll find out. I don't have.
It's not here in the.
Not here
okay,
in my
okay.
petition.
Yes, it was Dasi.
Anasana, ito mo silent. 524. Date kena?
Mr. Gyal, anything more to counter the submission?
Oxip, Supreme Court in 2005 by full bench stated, Lordship, I'll supply the copy. I'm reading slowly. Paragraph 7, it is title law that the personal liberty cannot be taken away except in accordance with procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedure established by law. Under the criminal law of this country, a person accused of an offense which are non-bailable is liable to be detained in custody during the pendency of trial unless he is enlarged on bail in accordance with the law. 2005, 2 SCC page 42. Name of the parties are Kalyan Chandra Sarkar versus Rajesh
So
Ranjan.
3 days back, there was an order. You look at that order.
Which one?
3 working days back, there was 3 days back, there was an order by Supreme Court of India granting bail in that PMLA matter.
Yes, Lord. I know.
You see the observations there.
But see, before a week, there are, in case of NDPS, the observation of the Supreme Court is very interesting. Lord.
What is the citation?
This is 2005, 2 SCC page 42.
Can we have the name of the parties?
Yes, Lordship. Kalyan Chandra Sarkar versus Rajesh Ranjan, alias Papu Yadav.
2005.
2005, 2 SCC, page 42. Lordship is speaking about this Manoj Sisodia's case. Manoj Sisodia's case. I've gone through that.
Names I don't remember, but yes.
Yes, Lordship.
PMLA I would remember.
But before that, Lordship, weeks ago, in case of a case that's come from the state of Meghalaya, where bail was granted on the ground that the accused was suffering from HIV. The Supreme Court, while dealing, cancelling the bail, Lordship made some observation in paragraph 5, 6, 7, and 8 in placing that judgment, Lordship.
So this Lalran Bomnia.
Yes, Lordship. So, Lordship,
You must give this citation. My
whether would need it copy. Yesterday, See, on last week, I was arguing a matter before the division bench. The matter was relating to alternative remedy. The latest judgment is there of full bench. There are some contradictory judgment also there. The counsel of the appellant, he was submitting that there are conflicting judgment. Then this court observed that when there is a judgment of full bench, then court is bound by that judgment. Even then, lordship, some contradiction is there. The same case is here, lordship. And lordship, in case of Advan, the matter was related, in case of Kapil Vadvan, that may relating to default bill. In that case also, lordship, Supreme Court says that when charge sheet has been filed, and investigation is pending against some other accused persons, then it will be section 167 will not come into play. Similarly, in case of Gang. Okay. And lordship, even if default bill is granted, if there is a heinous crime, then Supreme Court says that bail can be cancelled.
No, cancellation is something else.
No, lordship,
That here is a projection that the initial order of his being detained in the jail itself is wrong.
No,
And therefore it's a continued wrong. That's the submission of the
and a trial court by dealing with also address this question also. And lordship, he was produced before this court through BC. Whether he was granted.
Those judgments, please cite because we'll have to.
Give us your list.
We will have to.
I'll give the list.
We could give a list.
I'll give the copy also.
Give
I'll
the.
provide a copy, sir.
Copies are not necessary, the citations are necessary.
I'm giving just,
Give it to them.
I'm giving just
We'll take it up next Monday.
lots.
Meanwhile, you can see the trial court records to see.
I'll assist you lots. Listen.
এটা পাইছো 52 দুটা দিছিল নহয় এটা পাইছো অলপখিনি আছে
Basically, we're interested in 524 capital A dated 2/8/2023.
There were two petitions filed for shown arrest. 524 is subsequent one. Earlier one I got, I think that will also be there. I'm just looking.
Okay. Mr. Khan, just flag it and give it because today we'll have to break up. We'll fix out next Monday. In the meantime, you flag those.
Yes, one I have flagged, another. I'll go through my lot for half an hour.
Much up.
The submission was. Oh, no, not now. Tuesday. The submissions of Mr. F. Khan, counsel for the petitioner, and Mr. S. C. Kath, standing counsel for NCB, have been heard in part. List is parted matter on Tuesday, 2/8/2024.
At 2 PM, my lord. At 2
I'm not saying time, make a mention,
Man,
we'll accommodate. Both of you agree to a time and then make a mention.
Much up.
grateful, my lord.
The other criminal matters, 46 to 51. We are proposing to take up the matter tomorrow because we'll have to break today. Tomorrow we are proposing the matter to be taken up.
Who will be day after, because tomorrow I have some personal difficulty.
Thursday, I think would be more better.
Thursday, holiday. Thursday of 15 August.
Oh, 15 August.
Oh. Then 14th.
15 day after.
Day after tomorrow.
Kali 9 actually. So that would be at 2, my lord, that way to.
You agree to a time, we'll take it up.
On that day, we'll.
You. you consult with, both of you can, fix a time and come.
You lost the motion matters will be there, my lord, some other matters will be there. We will also, other matters, we will also host.
No, it's okay, you just agree to a time and come. In the order, we are not saying time, but both of you can, decide that. Due to all sides are represented, due to paucity of time matter could not be taken up today. List on 14/8/2024.
All right.
This is because more than 3 months have passed. So there has to be a hearing and then the time be extended. That's number one. But number two, the evidence vis-a-vis of the PWs vis-a-vis the exhibits, which the compilation both of you gave, was not complete. So it is taking up a lot of time. The compilation will show you. What with the compilation evidence? Yes. Now this is what has come up. And there will be some addition more.
Lordship, if I remember correctly, Lordship, Kohima Lordship has indicated some 100 and some 26 or 36 paragraphs written.
You know, the difficulty will show you why. Because every time we read this, when we are reading this paragraphs, reference to exhibits, specifically that Swam Prakash Pani and all, it's so elaborate that unless we have the exact evidence, we are unable to locate the document. Means unless you say it is exhibit 115/59, we are unable to locate that document. And therefore, there is some overlapping coming in. Then we find a strange thing. Few of the documents was exhibited by one person, signature was exhibited by another. Unless we look at the document, we don't know what is happening. Few of the documents were seized by Nulmati police. But seizure lists were exhibited by another witness. So we are now not finding the connecting documents by which the seizure list was seized. So unless that document is identified, we are not unable to look at the.
That is understanding. And it's been just like a CBI, with so many documents.
Now, this is, you see, you made that, both of you gave that the record of evidence. Now you see, this is what we are now finding. You can come over to this side. Mr. Prasad, come over to this side.
Actually, we can.
ঠিক আছে
এখন আপনি দিছিলেন নি?
হ্যাঁ ঠিক আছে তখন কি হবে
হ্যাঁ।
I was referring to which witness, which accused.
Yes, that is.
And now look at this. It Razi.
No, no. Sorry, there's no exhibit. Okay.
Which document is this whose signatures are there?
Some of these are not there.
No, it's not there. That's why we are taking so much of time.
Because I don't see 32 here. I don't see 32 here.
It has to be there. It will be in the first page.
Oh,
1 to 30 is there.
Yes.
After that will come 32.
What we have to go through the evidence, you know, So not only that, we have to look at the document.
Yes, yes. Lordship. Subject to if your lordship permits. Can we redo that table? Can we redo that table?
Pardon me?
Can we redo this table?
No, we have already done it. It's under correction now because now I can't part with this.
No,
Yeah.
I can.
No,
Yes.
because you will not be able to do it. That much of time you will not get. All three of you are busy persons. You will not get that much of time. Even if I tell you, you will not be able to do it.
Lordship is the best correct.
Because now I have to have this document, otherwise I can't complete. Because now we are rechecking the documents. Yeah, unless we identify the documents, it's very difficult. And there's one aspect, Mr. Prasad, you will have to tell us. This Exhibit 5 series contains the photographs,
Photographs.
correct?
Correct.
That list does not have a mark. It is an attachment. What is that? What is the number of that list? Exhibit 5 contains the names of the photographs and the names. Exhibit 5.
Exhibit 18, I think.
Huh?
Exhibit 18.
Exhibit 18.
18, 1-8,
Then what is Exhibit 16?
18. I think.
Because you see in that page, in somewhere in the middle, they have written the exhibit. Now, which is the exhibit for which accused person? How do I identify that?
They have exhibited the entire list.
Hmm?
They have exhibited the entire list.
But then how can we identify? Please show it to Mr. Das also.
Otherwise, exhibit 5.
You see, there are several accused persons. In that list, there is a photograph of the officers of UNLF. Now, which is the photograph of which I have not been able to identify? Out of this, look at this document, then you will understand. Come to that exhibit. Let us say accused number 6. If there is a photograph, how is that photograph identified? I have not been able to find out.
Now, this exhibit 5 was exhibited by the
M. Bhaskar.
CFSL. He simply says, this is an attachment of officers which was sent by this email to that email. And we have just printed it out and given it.
So it does not identify.
He has not identified. Not
So therefore, the comparative photographs is also, it would not have been identified.
Not with adequate birth certificate brought.
Because those were a part of the emails.
That is, it was all downloaded, my lord.
That paper book, please pass it on. No, that photograph also, if you have. Mr. Prasad, if that photograph also you have, please pass that also. Paper book 1.
He says exhibit 5 is an email sent from so and so.
Okay. Yes, down below you see this is the marking given. So this marks refer to which particular person?
Okay. They have exhibited the entire list, the entire photograph, which was a part of the email. And while arguing, they have referred that serial number so and so is this appellant or this accused. The contents of the email have not been proved. Contents of the email has not been proved.
That we have taken note of. But we are not being able to identify this accused person from these photographs. That is it, and there's one missing link. For that Aegis.
No.
Have you filed any affidavit? I did not find.
But this was discussed in the judgment at paragraph 45, 46, 47, page 970.
Page?
970 of the judgment.
970.
970.
Of Aegis.
Of, I think, would be part 1, volume 4, I think.
Yes, this will be part 1-4.
Judgment of part 1, 4. Okay. 970.
Examination of accused person.
970.
No, Aegis was not an accused person. Aegis is not an accused. This appeal is under 25(6). Aegis is not an accused person here. Aegis is against the order of attachment, and
Yes,
for that appeal is filed under 25(6).
yes.
So the reference to the judgment should not have been there.
For attachment. No, I don't.
It is against the attachment.
Against the attachment of the properties, including assets and that pineapple manufacturing unit. So this appeal,
Yeah, there is an appeal, my lord.
so that appeal is of 2013. And that appeal is presumably against the order of attachment, and therefore reference to this judgment would be a passing remark. It can't, the trial court could not had no business to give a judgment. But let us see that volume 4, part 1. And in that appeal, I have missed it out. There's no affidavit filed by the
But we have
prosecution.
filed that, I think.
Huh?
I see.
Is there? Page 970. No, it will be volume 5. Volume 5 तो नहीं होगा. 970, volume 5. Nine 70 does not refer to ages.
But that criminal appeal is 25713, 2013.
13, yes.
2013. Because all this criminal appeal that was finally decided in 2016.
The case was decided in 2016,
Yeah.
but 2013 normally should not have been there in this judgment.
But final order was passed in 2013. Against that,
This appeal is
the
proper.
appellant filed in 2013.
So
because
you
that-
see, the query is that is the missing link. If the accused, Aegis is not an accused,
Aegis
Aegis is not an accused,
is
so therefore, in the memo appeal, we don't find it. In the judgment, they are not an accused.
Worship, if I may just point out, worship, it page 948 for a minute. 948.
Yes.
What if it comes to accused 16?
Yes, Bhumi Singh.
Bhumi Singh.
And Bhumi.
And Bhumi Singh is the secretary of Aegis.
No,
So Aegis by itself is not an accused.
is not accused here.
Itself
Now
is
the question is that if somebody is not an accused, how can its property be attached?
not-
Confiscation of the property was all of this Aegis. That is the missing link I have not been able to trace out.
But so far remarkable, but all the proceeds.
No, you
of
see,
the
in a PMLA case, what happens is that when you travel with the money trail,
Yeah.
you say that the money of A
Yeah.
was used for purchasing a property B, which is a Benami property. And beneficial holder is so and so. Correct?
Correct.
So we go by that premise.
Correct.
That, okay, you are following a money trail.
Correct.
But no evidence is there that Aegis is having any money which is at proceeds of crime.
for that matter, a proceeding was started, my lord. For that,
No.
just a
Proceeding
minute.
is one part.
Uh,
Proceeding, I understand. After
they
proceeding, you
did
have attached.
they did not
But where is the
give the
substantive?
information that this
No.
money,
You see, the predicate offense is what? Predicate offense is this present NIA case 1 of 2020,
go true.
correct? In this predicate offense, where is the evidence that the money A, which is a proceeds of crime, went to Aegis?
My lord,
You have attached the
course, sir.
property when the evidence is that the government of India funded them, two ministries,
Yeah.
Ministry of Food and Ministry of Industries, Food Processing and Industries, two of them funded.
my lord.
So if that is attached, it is presumed that government of India is also an accused person, which can't be, a state can't be an offender. Because then what happened? Proceeds of crime went to the government of India, and government of India through Ministry of Industries and Ministry of Food Processing gave it to Aegis, and you seized Aegis property. That is nobody's case. So you can seize a property to the extent this is a proceed of crime.
Yeah, true.
So
Proceeds of crime.
if Aegis are having 100 rupees, out
Yeah.
of which 2 rupees is funded by proceeds of crime.
But what we say, that the extorted money was put in here.
But then who did it? Government of India.
Yeah.
So that means extorted money was taken over by government of India and routed to them.
Not
through
government of
grant.
India, not government of India, but a person who are
No.
running this Aegis.
But there is no.
No, two part. That is one part that has come from government of India. True. True.
No, you see,
This one part, this one part.
when I was
that
in,
could not have, that is.
when I was at your side,
That is our
we dealt
case.
with income tax cases.
Yes, we'll have to go through the evidence again.
We
but
dealt
I
with
felt-
income tax cases. But in income tax, what happens is that
No, true.
you'll have to find out the exact amount which is undisclosed. So here in this, they say that 276, the outlay of project was 270 odd crore. Correct. Out of 70, they have shown that they have taken bank loan, they returned the bank loan, they had a 65 lakh rupees, 65 crore rupees deposit, which they broke. And then, what you call, two amounts from the government of India, and they funded the project. Now, what is there to deny that this fund was not given by the government of India and was a proceeds of crime? If that is correct, because you have not even done a calculation from the balance sheet, that the balance sheet has this much of amount. And therefore, this is the extra cash which is coming.
Well, what your lordship has been saying is correct, but nothing has come from the mouth of Bomi Singh, was the secretary. That is
No,
what.
you
your-
see, it is not his money.
Because it will be only surmises that what your lordship would.
No, he is defending himself.
Madam.
He is not espousing when he is an accused in his own name. He is not expected to espouse the cause of Aegis. Aegis is an independent appeal.
Madam.
Why Bomi Singh never came and said that, yes, I am the whole and soul of this. He said that I am a staff here.
Madam.
So therefore, a staff will only say to the extent he knows.
But in a pursuit of crime, they are bound to say something that these are the money.
So that's what we are asking you. First
From the
question
government
is,
of India, that's
first
the-
question is that
that is not
Aegis is
there.
not an accused.
No.
Therefore, who will come and explain? Reverse burden was not there on why Bomi
But the
Singh.
but the law says that notice should go to so and so.
Notice
is
is your case that you did not give it to him. You
Yes.
gave it to,
Yeah,
not to Aegis.
No,
You gave it
but-
to this, what do you call?
So if the law says that notice should go, that means a reply should come from them.
PW 23. That is the person to whom notice was sent.
Guwahati ke Guwahati. Dikhai diya Guwahati.
PW 39, NG Robert Singh. He gave you that 17 lakh rupees. So this notice was given to him, NG Robert. Lukesh Nirban. Mr. Chaudhary, I'll tell you the thought process. Number one, if, just as I said in the last few moments back, you see, the Aegis was not an accused person. Therefore, action of Aegis was not required to be defended. All the people are defending their individual involvement in the crime. That's one part. The second part is that even if there is any examination or cross-examination or a reference by the court to Aegis, would only be for the purpose of showing that these people are working in Aegis. PW, this accused number 23, 24, 25. They were never charged of handling proceeds of crime. The individual person was a secretary, but he was not charged that this amount extorted went to you and you invested here. That is not even a charge because they are not the accused person. So therefore, charge could not have been there. So we are proceeding on that premise. That if the charge is not there, then the second part is that how is the proceeds of crime identified? Number one, they said that they have an asset of say 250 crores. Out of 250 crores, which is the proceed of crime. Then second thing, to find out this, what is the extent of the proceeds of crime? The second part is that you'll have to identify those people from whom extortions were made. They would have come and said that, well, 1 + 1 + 1 + 1 becomes 250 crore. And therefore, this 250 crore is the proceeds of crime. You have to identify that.
From where it has come.
From where it has come. So when on face of it, they are showing that Government of India and the bank has financed them, then to say it is a proceeds of crime is an accusation against the state, which prima facie is not acceptable. So that evidence is nowhere. I did not find anywhere that evidence being led.
Lordship, perhaps if I may take your lordship to the paragraph 54 of the judgment. It starts from paragraph 53.
Just 2 or 3 things, if you can note it down.
Yes.
PW 32 refers to, PW 29 refers to accused number 23. PW 43 refers to accused number 23, 24, and 25. PW 64 refers to accused number 25. PW 77 refers to accused number 23. And PW 79, he's your star witness who has referred to all three accused, 23, 24, and 25. And in his evidence, you will find he is stating that the accused were all arrested from Manipur and the properties of AGs is funded by UNLF. Then PW 24 refers to these three accused. PW 80. PW 80. There is no other evidence. So this omnibus statement of PW 80 saying that the properties were purchased by, were funded by UNLF. Mr. Das, Mr. Chaudhary, and Mr. Prasad, my brother has a single bench also. So we may rise, but if you find anything, please give that paragraph to the court master.
Yes.
He'll come to me.
Yes.
So we'll just say, this matter has been listed at the instance of the court as for
16
for certain clarifications. Full stop. Mr. B. Prasad, next para, Mr. B. Prasad, then counsel for the appellants, comma, Mr. R.K.T. Chaudhary, learned DSGI, and Mr. D. Das, senior counsel, assisted by Mr. D. Bharadwaj, counsel for respondent number 2. Full stop. No, not full stop. Have both addressed the court on the court query. Full stop. The matter is again reserved for judgment. But, it's not necessary now. Even tomorrow morning, if you can give, these gaps will be completed. And the query of the court is reiterated again. Number 1, this photographs of this accused in that email, they have not been identified. Only that much.
check it up.
If you find any evidence, even tomorrow morning, please give a slip to the court master. And you also check up. Because in the chamber, we don't have any assistants. We both have to do it ourselves. So we need that. If you have, it's okay. If you don't give, that means we'll understand it's not there. And regarding that AGs also.
Yes.
The pinpointed evidence, we have disclosed it to you. If you find any other matter, you don't have to refer to the judgment because that we have already seen. Judgment we are not referring. If evidence something comes out, please tell us.
I am interested of raising my.
Because if we may have missed it entirely. That is one part. The second is a practical aspect. Having read same set of evidence for 17 times, lost interest. Because for every appeal, you have to read the entire same set of evidence to find out. That's why we wanted that chart. But then our job would have been easier, but the chart is not complete. So we discarded those 2 charts and proceeded of our own.
Insofar as PW 39 is concerned, is related to
accused number 6, Rakesh Singh, not ages. Not ages. He was in the notification.
Rakesh Jain, he says that the
And
accounts were
Rakesh is
not.
not related to ages.
He's not related to the ages. Okay. Okay.